Current abortion law in Northern Ireland is incompatible with Article 8 of the European Convention on Human Rights, that is the right to respect for private and family life, and with Article 3, the right not to be subjected to inhuman or degrading treatment, in those cases where the pregnancy is the result of rape or incest, or the fetus suffers from a fatal or serious abnormality. Those are the major issues in the case. But the Attorney General for Northern Ireland has raised the preliminary issue of whether the Northern Ireland Human Rights Commission has the power to bring this sort of challenge before the courts. The court is divided on both issues, but in different ways. On the preliminary issue, a majority of the court, Lord Mance, Lord Reid, Lady Black and Lord Lloyd-Jones, are agreed that the Commission does not have the standing to bring these proceedings. It follows that the court has no jurisdiction to make a declaration that the law is incompatible, even though a majority of the court are clear that it is. Thus, on the issue of substance, a majority of the court, Lord Mance, Lord Kerr, Lord Wilson and I, are of the firm and clear opinion that the current law is incompatible with Article 8 in cases of rape, incest and fatal but not serious fetal abnormality. Lady Black agrees in the case of fatal fetal abnormality. Lord Kerr and Lord Wilson are also of the view that the law is incompatible with Article 3. I shall ask Lord Mance to explain the court's reasoning on the issue of standing and Lord Kerr to explain the court's reasoning on the incompatibility issues. Lord Mance.
In these proceedings, as Lady Hale has explained, the Department of Justice and Attorney General raise an initial objection to the Northern Ireland Law Commission's challenge to the compatibility of Northern Ireland law with the Convention rights, namely that it is outside the Commission's competence in the sense of power to institute abstract proceedings of this nature. The relevant Northern Ireland law is found in sections 58 and 59 of the Offences Against the Person Act 1861, an act of the UK Parliament, and section 25(1) of the Criminal Justice Act, Northern Ireland Act, 1945, an act of the Northern Ireland Legislature. These acts criminalise abortion save where undertaken in good faith to preserve the life of the mother, a phrase which was held in the King Against Bourne in 1939 to extend to preserving the mother from becoming a physical or mental wreck, but no further. The courts below considered that the Commission had competence. The Supreme Court concludes, as Lady Hale has explained, by a majority that the courts below were wrong about this. It follows that the Supreme Court cannot give any positive relief in these proceedings. The challenge to the compatibility of Northern Ireland law with the Convention has, however, been fully argued, and apart from the issue of standing, I would conclude myself without real hesitation that the current state of Northern Ireland law is incompatible with Article 8 of the Convention in cases of fatal fetal abnormality, rape and incest, joining in that respect with the views of Lady Hale, Lord Kerr and Lord Wilson, who would have taken a different view from me on the question of competence. The purpose of this summary is to explain the majority conclusion that the Commission lacks power